Well, tomorrow, state lawmakers will gather at Jacksonville City Hall to hear from the public ahead of Florida's upcoming legislative session. And several families fighting to change the state's so-called free kill law are expected to speak. Now, under the current law, if you die because of medical malpractice here in Florida and you're over the age of 25, you're not married, and you have no children under 25, your loved ones can't sue. Tonight, we are sitting down with a state lawmaker. We're also hearing from a St. Johns County mother who wants the law repealed.
And knowing that my child, before I could even make it to Orlando from Jacksonville, was being failed by the very people who took an oath to do no harm.
Since Cindy Jenkins' daughter Taylor died this past spring in a Florida hospital, she's been fighting to change a state law that's been on the books since 1990.
I'm on a mission to hold them accountable through the justice system, and I find out you don't have access.
Taylor had just turned 25 months before she was in a car accident and rushed to the hospital. Her mother says doctors failed to recognize a torn artery that led to internal bleeding until it was too late.
So, I not only lost a child that day, I lost one of my best friends.
She believes her daughter was the victim of medical malpractice. She turned to numerous attorneys for help and kept hearing the same questions. Was Taylor under 25? Was she married? And did she have any minor children?
And I said no. And then I was informed that they couldn't help me because of this free kill law.
The law, which carves out two groups of people who cannot sue for non-economic damages due to medical negligence, was passed to combat the high costs of medical malpractice premiums in Florida.
And it shouldn't matter if they were married or have children. What's the value we put on life?
State Senator Clay Yarborough says Senate Bill 248, which has bipartisan support, offers an alternative for those currently shut out of court, because previous attempts to repeal the law have failed.
This may not be completely where some out there may want it to be, but it's still opening up a path that doesn't exist today under current law.
His bill would require those families to file a complaint with the Department of Health or the Agency for Healthcare Administration, who would then have to determine probable cause before a lawsuit could be filed. But Jenkins says that is a daunting task.
But what this bill really does is plunk Mount Everest in front of family members that have just lost their loved ones. And if you can climb Mount Everest and make it to the other side, and ACA or DOH finds probable cause, then you can have the same right as everyone else to our judicial system.
Two other bills have been filed in the Florida House to change the law. House Bill 129 would outright appeal it. House Bill 77 would remove the provision that prohibits parents of adult children from recovering certain damages in medical negligence suits.
The entire law needs to go. The entire thing needs to be repealed.
Andy Bolin represents healthcare providers and opposes efforts to peel back the law.
The litigation doesn't just strain the physician in that particular case, it strains the entire system. And when we have a state where more and more people are accessing our system every single year, we don't need to remove protections. I think we need to keep as many of them in place as we can.
Jenkins is fighting to change the law, knowing that repealing it won't change her situation, but hoping to prevent other families from enduring her pain.
I never want another family member to experience this, and I can't say enough. If the tables were turned and I had been the free kill, my girls would not be able to handle this.
And we will be at the Duval delegation meeting tomorrow. Now, the deadline has passed to sign up to speak at that meeting, but Senator Yarborough encourages everyone who is passionate about changing this law to contact your state representatives and senators.